Well, it's a great pleasure to be here, even if a bit unexpectedly. And I'm going to change the focus from the representative institutions that Mickey Edwards was talking about to the courts. Because when I think of the common good, one of the things I think of is how do we manage this huge society of ours where people are from such different backgrounds and we are seeking to be one country, but inevitably disputes do arise among people with some regularity. So we need to be able to manage them. And the way that most societies do this, among other things, is they have a system of courts. And in order to be a credible system of courts, people have to trust them. They have to think there's integrity in the judicial system. And they need to be willing to accept whatever result it is that the court comes up with. I often have seen this from the other side as I've traveled around the world and looked at other court systems that have not been so successful in those respects, court systems where bribery is common or corruption of other kinds or political influence or other things. And that leads us to the conclusion, leads most people to the conclusion that you need a credible system of what we call independent courts. Now that doesn't mean that I, as a judge, get to wake up one day and think, I like you and I don't like you, and so the first person is going to win. That's not the kind of independence we want. The kind of independence we want is the type that allows for the judges to decide based on whatever principles that particular society's law has given them. So what I'd like to turn to, and I'm just going to assume that we all agree that we actually do need courts and we need independent courts. There are challenges that our courts are facing in today's world, and I'd like to highlight three of them. The first one is the challenge of legitimacy. Perhaps you've heard the story of President Andrew Jackson, who reacted to a decision of the Supreme Court in the Cherokee Indians case. The court had found invalid a Georgia law, and the president was exasperated. So he reputedly said, "John Marshall has made his decision, now let him enforce it." Many others have made the points that courts don't command armies, and they're dependent on others for that kind of enforcement. Perhaps some of you remember what happened in Little Rock, Arkansas in the late 1950s when the governor wanted to block 9 African-American students from enrolling in Little Rock Central High School. The National Guard came out and backed up the court's order saying that they had to come in. Fortunately, we don't see this too often. The court's decisions are simply respected by the parties, and that happens even in the most contentious of cases, such as the case of Bush versus Gore in 2000, when you'll probably all recall a very disappointed Vice President Al Gore chose to acquiesce in the Supreme Court's decision, a decision that in many circles is still controversial, but he acquiesced, the country moved on. Recent polls, as Leslie mentioned, have shown an erosion in the public's approval rating of the Supreme Court, and that approval rating continues to plummet, 46% down to 42%, and on down. So there was a poll this year saying only 37% of Americans trust the presidency and the Supreme Court, while a meager 13% trusted Congress. Well, this is terrible. So what are the causes of this slippage? Well, one thing you know is that the court does deal with cases that people feel passionately about. And that's not just the Supreme Court, it's all of courts. It may be the death penalty for one person. It may be abortion for another person. It may be the right to express religious views in public for another person. It may be how does one address racial discrimination. These are all extremely important questions, and people have very different views about how they should be approached. And when the court takes sides, as it inevitably has to, it's going to leave some disappointed people behind. And so how do we work with that fact? I think the only thing we can do is assure people that the courts really are not just another committee of Congress. The courts are trying, or they should be trying the best they can to resolve even these most controversial of cases based on some kind of rule of law. I have no pat answer to how one can move away from this idea that the courts are really a committee. I regret sometimes when I see judicial opinions reported that, you know, somebody is judge or justice so-and-so, comma, appointed by President Reagan or appointed by President Clinton or President Obama or whatever president is you name. My experience suggests that there's a poor correlation on my own court between the appointing president and the judge's outcome in a given case. Not zero correlation, but a poor correlation. And we want to encourage people to reach above that, not just to stay there. So that's the first problem, the legitimacy problem, and we need to find a way to make our courts, once again, institutions that are respected enough that even the losers feel that they've been given a fair shake and that they can move forward in the face of this loss. The second thing that I want to highlight is what I'm going to call the public face of the courts. Courts, you might think, are open institutions. If you want to go watch a court, you can pop into the courtroom someday and see the judge and a jury, perhaps, and whatever the proceedings may be. And we've had an interesting debate, which we can turn to at some point, about televisions in courts, but that's not my real point. The big problem is a more subtle one, which is that the judicial business of the courts is increasingly happening behind closed doors. In the federal courts, on the civil side of the cases that are filed each year, only 1.2% go to a full civil trial. 1.2%. All the rest of the cases are resolved either on motions or such as dismissing for saying you didn't state a claim, or what's called summary judgment, where a whole lot of documents get filed and the judge decides whether there's really a dispute that needs trying, or they're settled. So there's a great deal of invisible justice. You can have all the cameras in the courtroom you want, and you're not going to see what's happening in most cases. That's at the trial level. The same thing happens in the criminal cases. The percentage of cases that are resolved through plea bargains absolutely overwhelms the percentage of cases that are tried to a full jury verdict. Again, it's in the single digits. At the Court of Appeals, again in the federal system, the same thing is happening. The Seventh Circuit, where we are, it covers Illinois, Wisconsin, and Indiana, has more oral arguments than any other Court of Appeals in the country, and our percentage is about 52%. What happens to the rest of the cases? Usually there's no lawyer on one side, so if it's what we call a pro se person, we just decide the case in conference. The Fourth Circuit, which is, you know, Virginia and the states around there, doesn't hear oral argument in more than about 11% of their cases. Again, what's happening to public justice? What's happening to people's sense of what the courts are doing? They're becoming bureaucratic institutions, and I think that's a shame. And I think it also perhaps ties back to the first point, the sense of legitimacy in the courts. The third point I'll just mention is the question of judicial selection and judicial retention. Now here, it's going to be very important to talk about both state courts and federal courts, because the problems are different. On the state side, we have many states, including Illinois, but certainly not limited to Illinois, where judges are elected in open elections, and anybody here who lives in Cook County who hasn't voted yet is going to go on Tuesday, and you're going to see a huge list of judges, and you're not going to recognize, if you're like most people, almost any of the names, and unless you bring in a little cheat sheet that the Chicago Bar Associations give you, where they've taken actually serious time to evaluate these people and suggest who should be retained and who should not be, you're really operating in the dark. Elected judges also suffer from another problem, which is, just like members of Congress, they have to raise money for their electoral campaigns. And who do they raise money from? They raise money from potential litigants. They raise money from corporations. They raise money from individuals with interests in litigation. They raise money from trial lawyers. And the Supreme Court has said, I think personally somewhat unfortunately, that you can't even tell a judicial candidate to refrain from stating how he or she is going to vote in a particular line of cases. Well, what does that do to the integrity of the judicial process, to that sense that everybody's going to get a fair shake and both sides are going to be listened to? It's terribly corrosive. Retired Justice Sandra Day O'Connor has been working very hard on the integrity of state court elections. This has been one of her primary projects since retiring from the Supreme Court, to try to bring greater integrity to the process of the selection of state judges. The Supreme Court has set some very broad outside limits. There was one case a couple of years ago called Caperton against Massey Cole, where so much money was poured into the election of a judge who was in the process of hearing a case dealing with a very large amount of money for that company, that the court said, you know, we've reached our limit, due process would be violated. He should have recused himself, that is to say, step aside from deciding. But there's a lot more, and it appears that the Citizens United case, married with the problem of judicial elections, is a whole area that arguably the Supreme Court wasn't thinking about when they decided Citizens United, but it's an area that is already starting to cause problems. On the federal side, we have a different problem. The judicial selection process, as I'm sure you all know, has become an elaborate political game. It's quite difficult for people to be nominated, to make it through the nomination process to an actual vote in the Senate. Just one small example from close at home, the Seventh Circuit, my court, has now had for 3 years a vacancy that should be filled by somebody from Wisconsin, but for one reason or another, it's not happening. So we are simply one judge short. That happens all over the country. There's nothing unusual, unfortunately, at all about this. So the willingness of people to put themselves forward to be federal judges has been reduced because of this lengthy time period, because of the incredibly detailed investigation of one's life that goes on, and that's a problem. Perhaps even more troubling is the problem at the back end. Our framers created a system for federal judges that they thought was going to assure life tenure as one of the guarantors of the independence I talked about. But of course, lifespans have changed. So there are a lot of people who are looking at age 65 and they think, well, since federal judges don't get cost of living increases anymore, much less raises, maybe I'll just go and earn a lot of money. And so maybe the judges aren't quite as independent as they should have been if they're looking forward to the next job. And the number of judges leaving in that respect, in that way, has been increasing over the last 10, 20 years. So our notion of having judges who can simply look at the case and decide it as they best believe is threatened. I won't say it isn't happening, because I think there are a great number of people who are still working very hard every day to achieve that, but there are real threats, both on the state side and on the federal side, to the kind of system of justice that we want. And I think that's probably about all I'm going to say. I think we have depended very much and benefited very much from a court system in which people have confidence, and I hope that we find a way forward to assure that for the future.